Hi everyone, I'm Jaya Vishwanathan, and you've found the No Brainer podcast where I discuss all things neuroscience in delightful conversations with various experts. I hope you enjoy today's episode. Research has always been kind of based on college educated, because that's where you recruit your participants.
That's right.
Predominantly male, Caucasian, European, American kind of subjects who are participants who are like invested in healthcare. But then when you look at minorities, different populations, there's a distrust of government, there's a distrust of the institution, and so they don't participate in clinical trials. So it's been like hard to get insights into what their biology or how their biology might be different. So do you see a similar kind of discrepancy in the criminal justice system?
Absolutely. I
Okay.
mean, just what you were saying. I mean, so many of these cases, at least the one that gets the headlines, are people who are Caucasian and they're
Hmm.
educated and they're able to afford attorneys who are going to get the case in the headline, or the expert who is getting very highly paid to testify in their case and get all sorts of neuroscientific evidence that might explain their behavior. I've definitely been focusing on people who do not have that level of access.
Right.
And I want to put a spotlight on them because they've been ignored or people haven't been aware of them. So a particular case that fascinated me involved someone who was just that. I mean, this is, the defendant was living, this is in Albany, New York. The defendant was a man of color. I actually ended up talking to his public defender attorney because I thought that he had done such an amazing job on behalf of his client. So his client ended up killing a prostitute who he thought was trying to get into his house to kill him. And there was no basis for that. It was actually a very interesting case because it was used to argue that self-defense on his part,
I
because he
see.
believed that she was trying to get into his house to kill him. And this is in a very impoverished part of town, et cetera. So the attorney takes this case on but it becomes very clear, and when I was talking to him and also just following his briefs and the kinds of tests that he administered, that he thought something was really wrong with this
Yeah,
defendant. And so he went and investigated his medical background. I mean, the defendant had been hit by a car when he was 7 years old. He had been in and out of the hospital, for much of his youth.
hmm,
There was a lot of physical and mental abuse when he was growing up in his family.
I see.
And this defense attorney, just a public defender who has, right, a million cases, ends up hiring an expert to also conduct brain scans to argue that this defendant really had severe brain damage. And this would have affected his behavior or his perception of what went on and why he would kill someone. And the court or the prosecution wanted to keep out the imaging
Mm,
data.
mm,
It was allowing everything in, but it wanted to keep out the imaging, saying it wasn't necessary, it was redundant
mm.
with everything else that was being introduced, such as years old medical data.
Yeah,
But this defense attorney really fought very hard to get this evidence in, and it did have an impact on the jury. The defendant still was punished. I mean, he ended up killing someone, but wasn't convicted of first-degree murder. It was manslaughter. And I think, I just looked him up the other day. I think he's still living in Albany, hasn't committed any other kinds of crimes. But
mm,
I was just so impressed with this is, somebody who's you're never going to see in the headlines, but still,
yeah,
even in a case like this, all the effort that the prosecution makes to keep this evidence out.
yeah. And that's fascinating too, because it is this common? How common is this? Because this seems like to me, as you're telling the story, feels like the exception, not the rule. That
Oh,
that someone is investing this much for, yeah,
yeah, it's definitely the exception, unfortunately.
yeah,
That's
yeah.
why I really wanted to talk to this person and
Yeah.
tell him how in awe I was that he went to this effort. Most of these cases are, the representation is extremely poor. These are defense attorneys and who are simply don't have the time or aren't going to take the time or don't have the knowledge base to uncover prior history evidence or any indication that a defendant may have some kind of brain damage or severe mental illness, because these defendants aren't going to have access to therapy or the kind of care that we're going to be seeing with someone who has more money. The great majority of people in my database are impoverished. They are going to be low educated. I don't know what race
Yeah.
they are. That's not reported
I
in
see.
the legal cases that I'm looking at. But it's very clear that, just statistically speaking,
Yeah.
given the way the death penalty is administered in this country, that it would have a disproportionate number of people of color. So this is the typical defendant as opposed to the Fifth Avenue Manhattan executive who has a
Yeah.
fight with his wife and throws her out the window and can hire a whole team of people to help him.
Right. So I have a question about your methodology because you have cases going back to 1800. So I imagine that not all of these are digitized. It must be like, and again, I have no idea of or conception of like how big this database is. So, but I'm imagining like hundreds of cases per year that are like files that you're pouring through to get all these little details. And I'm just in awe of this work that you're doing and your team is doing. So, you talk a little bit about like again, the process of like sifting through these different cases and finding the information and the cases that should be highlighted in order to like propel the change.
Yeah, I'm really glad you asked that question. So I'd love to say that we're going through individual cases and things like that. We don't do that unless I pick out a case that particularly interests me that
Okay.
where I might look at it a little bit more closely. But in the legal system, we have a huge database or two competing databases. They're called Westlaw and Lexis. And they digitalize every legal case in theory that gets into the court system. And this is the database that I'm working with. So thank goodness I could never do this
Yeah,
otherwise.
yeah, yeah.
And these companies, Westlaw and Lexis, also do the same in at least 60 other countries.
Wow.
So it enables us to do international comparisons as well. And
Okay.
I've looked at studies done in other countries, about a half dozen studies, and compared them with my findings as well. So it makes it much broader where you could sort of have these international comparisons. But these are companies that have hundreds of employees working
Yeah,
on these cases on a daily basis. So I'm able to go through them, um, you know, and pick out criminal case and do it that way. Now, we still have to come up with a definition of what constitutes neuroscientific evidence. We created our own definition and put that into this system. So it may not be a definition that everybody would agree with, but that's how we started doing this. At the same time, we just can't look at these cases. Again, we have over 9,000 cases now. Every summer, I have research assistants who are coding these cases. We train them for 5 days. They code the cases for about 150 variables.
yeah.
Some of these cases are incredibly long, up to 200 to 250 pages long.
Wow.
And so we have massive Excel sheets that we're working on. So I can say, how many cases use MRI, how many cases use PET scan, et
I
cetera.
see.
So the strength of this database is, it's anybody could look at the cases I'm using because
Mm-hmm.
they're available to anybody who has access.
Mm-hmm.
And certainly all lawyers do. And they could validate me or see whether I'm doing something correct or something like that. The downside is you're not going to get every case unless it's published and it's a written case. It's not going to be in this database. So there are, of course, endless numbers of cases that we're aware of that just never have a court opinion written on them. And
I
those I'll
see.
never see.
I
And
see.
what's happening there, I have no idea.
Right, right. No, that's really fascinating too. And I'm guessing that this involves things like court transcripts and things as well. Or
Yeah,
yeah,
it
yeah.
does. Mostly what these cases, some of these cases are quoting court transcripts, but it's really a written legal opinion by a judge.
I see.
And so my perspective when I'm looking at these cases is from a judge's point of view.
I see. Yeah.
I mean, I sort of have to take on that perspective because these are judicial opinions. But I also want to take on that perspective because it's really the judges who are creating precedent in the legal system and writing the cases that other attorneys are going to be depending on. So I'm looking at it from that particular, that kind of perspective. That's
Right.
number one. Number two, there's a ton of information that never gets digital. So we'll not see it, or for court transcripts, some of them are very expensive. You have to pay to get a hold of them.
I
So
see.
it's just not
Yeah.
worth it.
Yeah.
And number three, I'm more interested in what the judge is saying
Yeah.
as opposed to, necessarily how evidence is being introduced in court.
Yeah. And no, I think the richness of your data set comes from many places, including the fact that it's so long standing. You're never, as scientists know, like you're never gonna have the perfect data set.
Yes,
It's never
exactly.
possible. So I completely understand that. So I'm kind of curious about two things from what you just were talking about. So one is, can you share some of your insights from your international comparisons about like what works well, what doesn't work well, and are there lessons that we should be thinking about?
Yeah, absolutely. I mean, I think first of all, when you do international comparisons or look at what's happening in other countries, the United States usually stands out because we do have a death penalty. And
Mm,
the other European countries that I was looking at, Slovenia, Canada, the Netherlands, England, and Wales, these are countries that don't have the death penalty. So you can readily see what a huge impact that has from the very beginning when you're doing any sort of comparison. Because in the United States, most of the neuroscientific evidence is going to be attempted to be used to argue why a defendant shouldn't get the death penalty. So it's going to be mostly used at the sentencing phase. That doesn't necessarily mean it's not also used at the guilt phase, like whether or not somebody should get the insanity defense or whether or not they had diminished capacity, or the case that I mentioned to you, whether or not they can use this as self-defense. That certainly happens. But in the United States, it's much more at the sentencing phase. Whereas in European countries, and I think we can learn from this in the United
mm-hmm.
States. The evidence is much more apt to be used at the guilt phase. Why would we not maybe even want to process this person into the criminal justice system? Why wouldn't we try to argue right away that they had diminished capacity and should get treatment rather than
Yep.
punishment? The
Yep.
questions and the emphasis are different than, a much more punitive perspective that's happening in the United States.
Yeah.
Really like what they do in Slovenia, which
Okay.
maybe many people wouldn't know. Slovenia is very treatment oriented. So even if they incarcerate someone or incapacitate someone, they regularly evaluate that person while they're being institutionalized to determine whether they have reached a point where they could be released and get a job and start to contribute to society. Of course, if they're too violent, that can't happen. But they recognize that in many of these cases, either for society alone or and for the individual's sake, that person should be tried to incorporate it back into the society as
Absolutely.
quickly as possible and
Yeah.
get the kind of treatment that they need. And in Slovenia, because it's so treatment oriented, they're getting treatment in the way that they wouldn't be in light of your, particularly one of your first questions, in the way that they wouldn't be in the United States. So I think it serves as a really great model for other countries, particularly for the United States to look at.
Yeah. Well, that is just fascinating. I feel like we've come back full circle,
Yes,
which
yes,
I
that's right.
absolutely love. Yeah. And so the other question I was kind of curious about is you said you've had developed your own definition of what neuroscience in the law looks like. So could you share that and what is the scope of like what you're defining as like, oh, this in this case, neuroscience has been applied?
Yeah, I mean, that again, another really helpful question. I have a very broad definition of neuroscience, again, going back to the issue that we didn't know what was we were going to be finding. So I wanted to have a broad net. So I basically use a definition of just about anything that's pertaining to to the brain, either of a defendant or a victim. And I ended up being grateful that I included victims because I found that was has been a very insightful level of inclusion. In other words, it's enabled me to look at shaken baby syndrome cases, for example, whereas in many of these cases in neuroscience is about the damage to the victim and what happened to them, as opposed to what happened or what's going on with the defendant. So this includes anything from brain scans just to expert testimony which may not be relying on any kind of device or technique whatsoever. And most of insanity cases are based simply on expert testimony. And if I hadn't used such a broad definition, I wouldn't really know that,
Yeah.
right? I mean, there was one very good study that only looked at brain scans being used in the criminal justice system. I can readily see that that's an incredibly narrow and distorted perspective on how these cases are handled. First of
Yeah.
all, so many of these defense attorneys either can't afford or don't have the level of sophistication to get an expert who could even administer a brain scan. That's number one. But number two, many experts won't use a brain scan or don't think it's necessary. So it's going to be their testimony about what happens.
Yeah.
So going back to my analysis of what I'm currently doing on looking at malingering or claims that a defendant is feigning in court, that's all based on expert testimony.
Right.
It's scary,
It is. Yeah. Yeah.
and you'd have one expert saying, oh, they're just making up the fact that they're schizophrenic. They don't really hallucinate. They're
Yeah.
not really mentally ill. And another expert saying, look at this person's childhood history. Look
Yeah.
at their public school records. They've been having, you know, been mentally ill for a very long time, and there's an
Yeah.
established record of that. But if you just have two people talking against one another, the criminal justice system is mostly, it's really oriented to thinking that people are going to be lying about something like this.
Right.
So, because you really have no other measure in
Yeah.
so many of these cases. And with a broad definition, I can really look at that very intensely and all the
Yeah.
associated problems with it.
Yeah. And like I was remembering one of my early psych classes about how like and even just memory, right? Like memory is so unreliable
Absolutely.
and like witness testimony. So I'm like, so all of this is just based on people saying and not what I would consider hard evidence, right? And people do lie. And so it's becomes, but then sometimes, people are sick. And so it becomes then really about, from what you're saying, who's the better communicator, the more convincing orator gets the win, it sounds like. Yeah. So that's scary. That's scary to
It's
someone
very
like, yeah,
scary. That's
yeah,
right. Who's the better expert? Who's the better attorney who can guide their expert? Because in a number of these cases, you could see an inexperienced attorney is not guiding the expert, and the expert tends to sometimes can say something that can be very damaging to a defendant inadvertently, and particularly in the malingering context, because some of these defendants will lie about
sure.
some things, of course.
Yeah.
I was just reading a case literally last night about a defendant who was lying about what was happening to him in prison because he really wanted to get to the hospital. He
Mm,
was being tormented in prison by other inmates.
yeah.
So he would lie about his condition.
Yeah. I mean, that's self-preservation, right? Yeah. Yeah.
Absolutely. Self-preservation. The expert, the prosecuting expert, used this against him, saying, look, this person has a history of malingering or a history of lying.
Yeah.
And so, of course, he's lying about hallucinations or being mentally ill
Yeah.
or why he thought his spouse was the devil when in fact, it was his spouse trying to wake him up or something,
Right.
something like that. So,
Right.
you're absolutely correct on it's who has the better narrative, who has the better
Yeah.
story, oftentimes who has the better attorney.
Yeah. Yeah. Wow. Yeah. And thank you for like this deep dive into like all these many questions and philosophical kind of tangents that I've been on, and thanks for sticking with me for all of that. But like kind of what we're talking about, like even lying and a lot of things are to me like transient state variables,
Yeah,
right? And so, and then like even coming back to lying, because I think that's a great example, right? Sometimes the way our own brains work is like if I do something that I can't live with, right? Whatever it is, even if it's something small, it's not like I hurt someone else, but and then like my brain can misremember it. And
absolutely.
then like over time, I'm convinced that that didn't happen or I didn't do that because I couldn't have done that, right? And that's not like a deliberate attempt to mislead anyone. It's just my subconscious not wanting to face the fact that I've done something, right? So for me, it's this kind of like then punishing them forever for something versus, or like, so you do something because your lack of sleep and you hallucinated and you did something and then you don't want to face it and you didn't mean to do it. These transient state variables kind of end up resulting in being labeled as trait variables like, oh, you are a liar because you lied about XYZ, right? And so, um, can you talk a little bit about like the personalization of criminal law, like going from neuroscience, which is usually like you do it on like 10 people, and then you're like trying to get to biological truth, but then a lot of the time you're dealing with in the criminal justice system these like transient things that are getting labeled as permanent things.
Yeah, I mean, this is these are really important issues. And number one, going to your first question is, we're always trying to look at what was happening to the person at the time of the crime. So, another difficulty in these cases is that, say somebody really is mentally ill, they're severely schizophrenic, etc. The question is, what happened at the very point when they engaged in whatever crime they're being accused of. And so we have to go back and reconstruct what was going on in that time. And as you're indicating, that might have been 5 years ago. Or, the witnesses are trying to remember what they saw, or even the defendant might be misremembering because they just don't want to realize that they could do such a thing, or they were out of touch with how they were perceiving what was going on at that time. We do have a number of cases of people having blackouts and
Mm,
and things like that. Much of these cases are reconstruction of something that happened years earlier for somebody who may be now even more mentally ill than they were at the time the crime occurred because
yeah.
they're being incarcerated and being in that kind of horrible environment that would affect just about anybody. So this is the kind of fiction. Everything's a fiction here on our reconstruction. Number two is the going of the issue is neuroscientific evidence does allow us to try to personalize the defendant,
Okay.
to provide information. I mean, this is really we have what's called mitigating experts
Mm,
whose entire job is to work on death penalty cases and to humanize and personalize a defendant so that when the defendant is before a judge or a jury, that the jury could empathize with this person and learn so much more about their background.
right.
And even in cases where you may not know why the person did what they did, if you learn about all their medical problems, you might view them differently, you
Absolutely.
know, particularly huge childhood trauma of, the man who's, talks about, the mother who slices the family cat to death in front of the entire family. I mean, that
Wow.
level of trauma. I have written about one case where a third of the defendant's brain was missing because he had had a lobectomy. Even in later,
Wow.
this isn't something that just went on in the 30s and 40s because he had epileptic seizures.
All right.
So, even if a prosecutor may say, we have no idea how this works, you know, you know, uh, you're
Yeah.
sitting there as a juror, you may think, well, you have a third of your brain missing. There's clearly a problem here. And I
Yeah.
don't need to know the exact causal sequence of how that works.
Yeah.
This is already giving me quite a bit of information about
Yeah.
this particular person.
That is just fascinating. So thank you. And what advice, kind of trying to like culminate. So when you were talking about how you train people to like do it, I was like, oh, can I volunteer, right? Like it just sounds like such a fascinating way to do like an internship or something. But what advice would you give to people who are really interested in being in this space like you and trying to like help people really because that's what it's like you're doing is trying to look at what's working what's not working to ultimately help individual people. So what career advice would you give folks?
Yeah, I mean, in your advice these days, it's always fluctuating based on what I went through. I think the biggest piece of advice is to suggest to people that they can learn on the job. You don't need a PhD or something like that because in all likelihood, a lot of that information is going to be out of date. Things are moving so quickly, particularly with artificial intelligence, which is getting much more incorporated into the criminal justice system. So that doesn't mean that it's not helpful to get a PhD in neuroscience or something like that, and you would develop the kind of employment context that you would need, and certainly learn a strong foundation in neuroscience. At the same time, if you're thinking of going into this as an attorney, working with experts, these experts can really help you greatly, and you're going to be depending very much on their knowledge base. What's important is that you understand them and that you know how to make them come across well in the courtroom. And there is maybe learning on the job or just learning to be a good lawyer. I'm no expert in neuroscience like you are. I don't write about which neuroscience tests have been the best one to be used
Right.
or do a deep dive in that realm because I'm simply not qualified. Where I'm coming from it is as a lawyer because I don't think there's been enough of that. And I think that aspect is very important. So, I this is all to say that, people can learn cases as they're handling them.
Yeah.
Most of my students, when they graduate, they're, in a year are going to be handling all sorts of corporate cases or dealing with all sorts of information that they have absolutely no background in. And
Right.
this would be the same thing. So, one of the people who has one of the most successful boutique law firms, boutique being a small law firm in the city here that's handling in neuroscience, he handles both criminal cases and civil cases, sort of tort. He started with a bachelor's in history.
Huh. Okay.
But what he does is he works very closely with experts and gets the on the job training that he needs to be able to ask good questions in the courtroom and be able to guide his experts in a beneficial way. And
Right.
I think that those are the kinds of skills that are most important.
Oh, that is such valuable advice. Thank you so much. I think that's advice that I'm gonna take to heart as well.
Okay.
Like I think that, no matter what project I take on, it's nice to go in with that like flexibility about learning new things. So I think that's
Right.
wonderful advice. Yeah. Can you share some, future projects or things that we can look forward to or any final thoughts? And first of all, I should say like this has been a completely delightful conversation. I am incredibly grateful that you've spared your time and your expertise. But I would love to hear any other thoughts, and I would, if you have future publications or works that you would like to share, also would welcome you back anytime to talk more.
And it's been a pleasure for me. You've done so much reading. You have such a great background and asking really pointed questions.
Thank you.
So I appreciate that. I'm currently working on a book project. I just finished an article literally last night on
Okay.
these cases online and how they're handled in the criminal justice system and how powerful they are and how prosecutors use this as a really effective tool to try to argue against the insanity defense in particular. That's been a big focus on mine, but I've been working on a book project for quite some time and I hope to finish that up so I can submit it. I do have a publisher, Oxford University Press, and I hope to submit it to my publisher hopefully in March or
Okay.
thereabouts.
Okay.
And with a book project, it really has given me an opportunity to, in a way that I can't always accomplish with an article, of looking at these very early cases, which are
Yeah.
just fascinating.
Yeah.
So particularly the first case where there was any attempt to do a brain scan. This is 1925, where the attorneys x-rayed the defendant's head because
Okay.
they thought this defendant had something wrong with them.
Yeah.
So I can look at that 1925 case all the way up to, what's going on today, to 2020.
Yeah.
And so every chapter is sort of going through a new decade, et cetera, and looking at the development. So that's my current focus.
Well, that is just absolutely fascinating. So it would be great to have you on, but I would be very happy to like link your book and stuff in my podcast when it comes out.
Okay,
So the
absolutely.
listeners can also go and I would love to buy it and read it myself. It sounds
Okay,
fantastic. So thank you so much for sharing that. And yeah, once you have your book, please let us know and look forward to that coming out
okay.
enthusiastically. Um,
Most definitely. Thank you
yeah.
so much.
Yeah, thank you. Hey everyone, hope you enjoyed this episode of the No Brainer podcast and see you at the next one.